Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near to the attendant and you shall be heard. Please be seated.
Good afternoon, lawyers, and I see a lot of staff members and colleagues. I think I know why they're here. What I'll do before the call of the calendar is I'll turn it over to my senior associate, Sally Manzanet.
Good afternoon. It is the custom of this court to celebrate the last sitting of one of our own, and this afternoon I have the distinct honor to pay tribute to my colleague and my brother, the presiding justice of this honorable court, the Honorable Rolando T. Acosta. Judge Acosta was born in Santiago, Dominican Republic, and immigrated to the United States with his family at the age of 14. He was raised in the South Bronx and the Washington Heights sections of New York City. From his early years, Judge Acosta was an overachiever, excelling not just in his academics, but distinguishing himself as an all-star athlete. He earned his undergraduate degree in 1979 and his Juris Doctorate in 1982 from Columbia University. During his tenure at the undergraduate level, Judge Acosta was a star pitcher, holding many pitching records that have yet to be broken. In fact, in October 2008, he was inducted into Columbia University's Athletic Hall of Fame for his season and career win records in baseball. We are grateful he chose to pursue a career in law and in the legal profession instead. He began his legal career as a staff attorney with the Legal Aid Society and became its director of government civil practice, serving as civil attorney in charge of the Brooklyn office until 1995. He also served as first deputy commissioner and deputy commissioner of law enforcement at the New York City Commission of Human Rights. In 1997, he was elected as a judge of the Civil Court of the City of New York in New York County. In 2001, he was designated an acting justice of the Supreme Court to preside over and spearhead the creation of the Harlem Community Justice Center. In 2002, he was elected to the Supreme Court of the State of New York, making him the first Dominican immigrant ever elected to that post. Justice Acosta has continued to be a trailblazer. In 2008, the Dominican community celebrated its first appointment with the nomination of Rolando T. Acosta as the first Dominican ever to serve as an Associate Justice of the Appellate Division, First Department. And again in 2017, with his elevation as the presiding justice of this court, making him the first Dominican to ever serve in that capacity in the state of New York. His leadership as PJ has been extraordinary. This court has experienced a modernization of its systems, making the administration of justice more efficient and accessible to the public. He navigated our court through the uncharted waters of the COVID-19 pandemic and in short order successfully moved our operations virtual. As a result, our court has been able to resolve all of our pending appeals before the annual calendar break in the summer since 2020. The beauty of his exceptional management style is that he inspires productivity without micromanaging. He encourages collaboration without compromising anyone's individual conviction. And he cultivates an atmosphere of professional camaraderie that transcends our differences of opinion. We hope that you know how much that has meant to each of us, and that it is among the many things we have so appreciated about you. Now, in addition to his commitment to the legal profession, Justice Acosta has always simultaneously served his Latino community. He has dedicated himself to a myriad of organizations and causes, Allow me to highlight just a few. Judge Acosta is a founding board member of the Upper Manhattan Empowerment Zone. He served as the legal advisor to the founding board of Alianza Dominicana and as treasurer and chair of the policy committee of the Hispanic Federation. He also serves as trustee of Columbia University and as a member of the Dean's Council of Columbia Law School. His impact has been far-reaching and vital to the Latino community, generally, and to his Dominican community in particular. As a fellow Latina, serving alongside you has been an incredible honor and source of pride that I shall forever treasure. My only solace is that with his retirement, our community will regain an important voice, one that will no longer be constrained by the judicial restrictions that limit our First Amendment expression. Hallelujah. I, for one, look forward to hearing and reading more of your thoughtful and piercing writings on the matters that affect our society at large. On behalf of your colleagues, the entire AD1 family, we wish you happiness, good health, and prosperity as you undertake the next phase of your career. Please know that you are eternally loved and will be terribly missed. Presiding Justice Acosta, mi hermano, we salute you. Please join me.
Thank you. Thank you. Thank you so much. Hector, wonderful that you came to the first department. You didn't ask me for a visa. It has been a wonderful last few months. I didn't know you would be here. Otherwise, I would have thought of something more clever to say, but it has been an incredible experience alongside you, defending someone with your integrity and qualifications to be our chief judge. But as you know, I'm constrained to say anything more than that. All I can tell you is I love you, man, and it's wonderful that I think that experience brought us together, and it gives us an opportunity, I think, to continue the battle to make sure that our roles as judges, with the constraints that we serve through precedent and statutory and constitutional restrictions, are not going to be affected, and somehow create out of the state judiciary a bunch of political hacks who make decisions based on who appears before them and whether they like them or not. We are constrained.
As your lawyer, I do not want you to be subject to any.
I'll stop there. Thank you, Hector. Much appreciated. So I want to thank Sally for her wonderful and heartfelt remarks. It has been quite an honor working alongside with you all these years. Thank you so much. But before we proceed to the calendar call, I would like to acknowledge that we are graced today with the presence of my wife of 43 years, Dr. Bati Reyes. It's not every day you get a chance to say that someone has supported you for your entire adult life. So thank you, sweetie. I love you. I would also like to thank the entire staff of the court and our auxiliary agencies for working so diligently every day to serve the people of this great state. In particular, I am grateful to our clerk of the court, Susana Rojas Molina, and my chief of staff, Adam Horowitz, who have aided me in steering the ship, and my chamber staff, of course, in addition to Mr. Horowitz. This includes my principal law clerk of over 20 years, Rosalie Vasquez. My confidential secretary, Yesenia Polanco, thank you, Yesenia, for all the support you've given me over the years. My senior court analyst, John Spicieric, and court officer, the one who has protected me for all this time, Gregory Williams. And I need the protection right these days. Last but not least, I would like to thank my colleagues on the bench, current and retired, some of whom have mentored me in my earlier years as an associate in this court, and others who have given me counsel in my role as presiding justice, and those who have challenged me to do better or simply make things work better and make it more enjoyable. So thank you so much. I don't believe that I need to tell you that serving, and this is difficult, that serving as presiding justice has been the honor of a lifetime. And I'll be stepping down with a heavy heart. Nonetheless, as many of my esteemed colleagues and staff will remain with my departure, I am confident that this extraordinary institution will be in good hands. Thank you all for being here. And now let's get to the business of the court and call our calendar.
Give your colleagues a minute to leave.
Thank you. Now I'm going to excuse them, because they're just going to make me cry. That's not going to be cool. I'll probably be the first PJ to do so on the bench. I didn't know Hector was going to be here.
I had him stashed in my office.
Yeah.
He wanted to surprise you. Thank you.
You're getting shot.
Okay, so I'll begin the call of the calendar. People versus Martinez Estrella.
Congratulations, Judge.
Thank you.
For the account 6 and 2, please.
For the respondent, 6. Congratulations.
Okay, thank you so much. 6 and 2 and 6. White and Case versus Shipman Associates.
Shipman Associates, congratulations, Your Honor, and 5 and 5.
5 and 5. Do we have
Yeah.
Congratulations, Your Honor.
How much time does
how much time do you need?
10 minutes.
Yeah. Oh, you won't need that many. I'll give you 5. If we need more, by all means. But I think that the issues are fairly simple in this appeal.
And for the appellate,
So-
how much?
Appellant, I'll give you 5 and 3, and then 5. If we need more, we can take more. So F. Agustin versus Stephanie F. is submitted. Hernandez versus 4624 28th Street. Appellant Hernandez. Thank you. 5 and 2 for appellant. Respondent?
3?
3. Thank you. Connor versus Gluck. Appellant Connor. Thank you so much. 5 and 2 and 7. People versus Sheldon Edmond. That's submitted. People versus Bracero is submitted. So I assume that people want to submit. Thank you. Bonacardi versus Mayor's Office? Yes, congratulations, Your Honor. Thank you. 5 and 2 for the appellant. Okay, petitioner 5 and 2, respondent? Okay, thank you so much. So 5 and 2 on 5. Global versus HBI Group is submitted. Hibbard versus American Finance.
Good afternoon, Your Honor. Plaintiff, appellant 9 and 6, please.
Thank you. Okay, 9. I don't know that you're all going to need all that time, but I feel generous today. Okay, first case on the calendar for argument is People versus Estrella.
Good afternoon. May it please the court, my name is Stephen Feynman. I represent the appellant. What occurred in this case resulted in the tragic death of a 15-year-old child. Regardless of the nature of this case, the people must not be permitted to rewrite the definition of torture under first-degree murder as they have attempted to do in their brief. According to the relevant statute, the people were required to prove beyond a reasonable doubt that the appellant and the co-defendants intentionally committed a series of distinct acts for the intentional infliction of extreme physical harm, and that they received pleasure in causing such pain. Right. The people in the brief do not even attempt to address any of those elements.
I mean, how will you how will you distinguish the underlying conduct in, for example, People versus Williams from the case at bar?
Oh, that and Valdez and Cruz, both of those cases are clearly different. In those cases, there was a significant series of acts over a substantial period of time. In Williams, it was over 19 hours. I believe Ms. Mazinette Daniels was on that case back in 2010, I believe. And in that case, again, the woman was sort of kidnapped for 19 hours, and during that time, the defendant committed horrible acts of cruelty upon her. He glued her mouth, slit her eyelids with a kitchen knife, poured acid on her face, poured boiling water, I believe, twice on her body, put scissors behind her knees, raped her several times, hung up in the closet with her arms and ankles bound, leaning on just her toes. And then he started a fire in the house while she was still in the home.
I mean, the people make much of the boasting that the defendant did in this case after he committed the act. Boasting about, I hit him in the neck, and I'm trying to distinguish the conduct because you're right. It's what distinguishes. I mean, what constitutes torture under our precedent? Is not whether we are inflamed by the conduct. I mean, this was horrible, what was done in this case. The question is whether it constitutes murder one, or whether we can say that this constituted the kind of torture that took place in, for example, People versus Williams.
Right, that's great. The tremendous amount of brutality and the series of acts over 19 times, this court determined that the only reason why anybody would have done that was they must have enjoyed causing the pain, and they intentionally caused the pain to cause extreme physical harm. In this case...
So you think of sense of pleasure in the infliction of the pain is what distinguishes this case from Williams?
Yes, in this case, there's absolutely no evidence to satisfy any of those conditions. In fact, the people don't even address those elements. In their brief, they conceded that the appellant did not have any type of was not pleased that he did not intend to cause extreme physical harm or that he received pleasure in causing such harm.
Counsel, what about the concept of course of conduct? Isn't that in the statute also, that there had to be a course of conduct? And your position here was there was really one major act that your client committed that stabbing him in the neck, which was serious but didn't constitute a course of conduct.
That's correct. In the statute, it says course, but the bill jacket, which is discussed in my brief, says there's a time frame, a series of distinct acts. And my client was only present at the scene for approximately 6 seconds. So it clearly did not satisfy the intent of the statute. The statute, I believe, since it was created back in the mid-90s, approximately 3 decades ago.
The only thing that really saves your client here, quite frankly, is the fact that all of the other stab wounds did not penetrate deeply. Had they, we'd be in a completely different situation.
Well, I would agree with you. According to Dr. Rodriguez, the medical examiner, all these injuries were superficial. None of them would have required any type of medical attention, and she described superficial as only the top part of the skin being damaged, basically scratches, cuts. So, yes, I totally agree with you, Judge.
Well, I don't know that I would describe it as a scratch when you're being poked by a knife or a machete, which is what these defendants used on this young boy.
I agree that
Again, they were lucky in that none of those strikes penetrated deeply. But if they had, then
We won't be talking.
we wouldn't be having this same conversation, and you would not be able to make the arguments that you're making now.
that's correct. It's like, take Vasquez Cruz from the 2nd Department in 2012. In that case, the individual stabbed the victim twice, once in each eyes, numerous times in the chest, in the neck, and the 2nd Department said it was as a result of each of those acts, that there was a series of acts, and the medical examiner, unlike here, testified that each of those acts caused extreme physical pain. In this case, the medical examiner never even discussed pain.
Okay, thank you.
Good afternoon, and may it please the court. Reva Grace Phillips for the respondent, the Bronx County District Attorney's Office. Viewed in the light most favorable to the people, defendant's brutal slaying of Lysandro Jr. Guzman Feliz constituted first-degree torture murder. I'll go straight to the course of conduct question. Your Honors raised the temporality concern that defendant raised in his brief. I'd first point to, and we cite to, People v. Payton, which was a criminal court case stemming out of Kings County in 1994, where 5 to 8 minutes of conduct was deemed sufficient to constitute a course. That case was cited favorably by this court in its decision on Ray Ivan, which was in 1996, and favorably by the 4th Department in People v. Ublink in 2014. There is no statutory requirement that the course of conduct occur over a certain amount of time. And I want to directly address defense counsel.
No, but it does require that the course of conduct, it requires that there be more than one act that causes extreme physical pain. And for me, that's kind of where I'm stuck, right? Because I don't see how we get past the medical examiner's report and an explanation of the injuries to this young man, okay? Because there's no question that the fatal blow was this defendant's putting a knife from one side of his throat to the other, and slicing the carotid artery. He bled out. But that was the only serious injury that was described by the medical examiner. And I don't see how we can get past that based on Williams and the other case.
Valdez Cruz, Your Honor.
Cruz,
yeah. Absolutely. So I would start by saying I think that the statute itself does not require that there be a series of acts which inflict extreme pain, each of them. It requires there be an infliction of extreme pain pursuant to a course of conduct. So the course of conduct can include activity that does not inflict extreme pain. And I think that's why defense counsel goes straight to the question of psychological pain. I think psychological pain here does expand the course of conduct substantially. And I would again contest, he said defendant was at the scene for 6 minutes. Defendant is the first person who approached Junior. And one of the first things that he did was say, "Are you a Sunset?" Junior said no, and then he made a motion as if to hit him, causing Junior to run. So I would argue that the course of conduct begins there, because from that moment, Junior is in fear for his life. He is aware of what will happen if he's caught. He understands the stakes.
But counsel, course of conduct can't just be a sui generis concept, right? That we have a fluid definition in every case. What's the working definition you would have us use in this case?
Yes, Your Honor. So I would say a series of distinct acts, and that series of distinct acts can include the infliction of psychological pain. So
and was
that
there any
beginning
break in the activity from the time that the victim was initially accosted until the time the defendant inflicted the fatal blow?
Yes, Your Honor, I would say there is, because specifically this defendant is staying outside of the bodega while other members of the gang go in to pull Junior out of the bodega. And I want to return specifically to the Valdez-Cruz case, which was raised by Your Honor as something that would be difficult to get over. The timeline in Valdez-Cruz is also fairly short. The Valdez-Cruz facts is...
See, I'm not focused on the time period, because, you know, someone could be killed in 3 minutes, and that's enough time. If you have sufficient acts and you need more than one that causes extreme physical pain. It does, see, because I agree with you, it is clear that this young boy was scared to death, and that fear could potentially, arguably, form the basis of part of the course of conduct. But I'm still stuck with just one act that actually causes extreme physical pain. And the case law says there has to be more than one.
Right.
So, Your Honor, I'd respond with 2 points. I don't think the statute requires more than one, and I don't think that the case law requires more than one. I would also say there was more than one act. While defendant...
more than one act that caused extreme physical pain. Right. There were a lot of acts, right? Like I said to your adversary, this kid was being kind of just jabbed with knives from various directions. Okay, I'm sure that had to hurt a little bit.
Right.
But extreme physical pain.
Yeah. And that's the difference with that. I mean, in Valdez-Cruz, you had the medical examiner testifying regarding several substantially painful injuries that were sustained by the victim. So substantially painful injury. Here you have one, right? So if we're talking about the psychological pain of knowing that you're basically going to be pulled away from the bodega to your death, is that what you're saying creates that course of conduct?
So I would say that the psychological pain expands the course of conduct. The psychological pain, I think, also addresses this question of whether more than one of these incidents, though they didn't leave deep puncture wounds, caused extreme pain. Defense counsel mischaracterizes the medical examiner's testimony by saying this is superficial, so it didn't hurt. The medical examiner expressly disavowed the use of superficial, a medical term, to describe pain. And here the psychological pain inherently amplified every moment of physical pain because Junior was aware that they were trying to kill him. So each one of these stab wounds that may not have on its own constituted extreme pain when combined with the fact that under his psychological pain at that moment, he was simply waiting for the coup de grace which this defendant delivered. Unless Your Honors have additional questions for me.
I think we do.
Thank you, Your
Thank
Honors.
you so much.
Congratulations again.
Okay, you got 3 minutes, Mr.
I would
Feynman.
like just to discuss a couple points. First, I believe the statute is pretty clear, the plain and unambiguous language as to what the elements are. But regards to psychological pain, the statute specifically excludes it from the definition. That's the reason why the trial judge never...
It specifically excludes it?
Well,
meaning it says extreme physical pain except for psychological?
No, it does not,
I
Your
didn't
Honor.
think so. You're
But
saying by omission.
That's correct, because it specifically says intentional infliction of extreme physical pain. It sort of eliminates psychological pain, because if you apply logical pain, then almost any gang assault would apply. Almost any homicide in which the victim has fear before his or her death would apply. The statute has only been applied a handful of times, and again, I've only seen 3 cases that have been reported on this topic. And again, the trial judge did not even instruct the jury on psychological pain because it's not really relevant to the issue of torture under first-degree murder.
Was there any evidence in the record to support a psychological pain charge anyway?
No, absolutely not. There was no testimony of anybody that even discussed psychological suffering of Junior. This is basically all inferred from the people's brief.
Okay. Thank you. Thank you, Mr. Feynman.
Thank you,
Thank you both.
Thank you.
What in case?
Good afternoon, and may it please the court, Andrew Hayes for the Appellant Whiten case. I, of course, have to begin by addressing the key issues and the key cases that are cited on the issue of how much and on what basis a law firm either stops work or quits or whatever, how much it can possibly recover. And Whiten case has cited the relevant cases in its brief. They've cited the same cases I cite. Whiten case cites not a single precedent from this court or any other New York court or any other court holding that when a law firm quits or is fired, it can recover exactly what is set out in its contract.
Even if the agreement itself provides for it, did the agreement say anything about what would occur in the event that they will withdraw or are fired for cause or not for cause?
It says if they are fired for any reason or no reason. It doesn't even say, just if they're fired.
Right.
They get 100% of their fees. That's what it says.
Right. And you agreed to that, did you not? Not you, but your client.
They did, although they also agreed to a clause that said if they don't ever close on the deal, they get a 50% discount. So a bit of a contradiction there in terms. And there's in fact another clause in the same retainer that says the discount is 30%. So not a model of draftsmanship.
But at this point, there's no judgment in Whiten case's favor for every dollar that they're seeking here.
Oh, correct.
And you have a full and fair opportunity if we, according to the order, to go to a hearing on damages and be able to say whatever you need to say to disprove X number of hours at X number of rates, and be able to arguably whittle it down to whatever sum you think is appropriate or not.
Right.
Well, absolutely. But that argument on remand, if it happens, should be in the context of applying a decision from this court on our Rule 3212G motion. Okay? We made a motion to Rule 3212G to limit the amount of recoverable damages.
But based on what, though? Based on the estimate of 700 to 900,000?
No. This court only needs to remind Whiten case of what it really already knows, what every lawyer in this room and in the city knows.
You don't think the referee will be aware of that when they considering the reasonableness of the fee?
Well, my concern is that Whiten case describes this argument, and Justice Bannon seemed to agree, that it was baseless twice, confusing once, frivolous once, made it up, they say, once, nonsense once, and they also say it was invented out of whole cloth. And Justice Bannon agreed with them. So it is the.
But I thought that Justice Bannon was referring to your arguments that the amount should be limited to the ratable proportion of the work based on the 700 to 900,000 estimate that was given by them. They're not bound by that, right?
No, they're not bound. And we said they're not bound by it. It's a guideline. Right. We cited 2 Court of Appeals cases stating that the terms of the retainer are relevant guideline for the trial.
I mean, you cite Cooperman is one of those cases, right?
Yes, no, but we also cite,
But Cooperman, in Cooperman, there was no agreement to a cap on the fees, right? So Cooperman is distinguishable from this case.
well,
Here, there was no
on
cap.
on that grounds, yes, but on the theory of the case is the same as Martin v. Cap. And we're not saying there's an absolute cap, okay? Because you're not even going to get to the cap.
But see, I don't understand, again, what the problem is, because I'm looking at Justice Bannon's decision, and she recognizes that the sufficiency of details and the fees is an issue of fact to be determined by the fact finder. So it seems like we're arguing something that really hasn't been decided. You have a dispute on the fees. They have a certain amount they think they should be entitled to. The judge, I imagine, is going to send this out for a attorney's fees hearing, which many cases are, that happens to many cases in Supreme Court. You're going to be able to make all those arguments there. So,
But that's, yes, we will make those arguments there, but it is this court's role here to set the legal rules under which that inquiry takes place.
I mean,
But we've done that. There's precedent. I mean, you have an agreement, right? You have an agreement that sets the parameter of that relationship, what they're entitled to. What happens at these hearings is always a dispute about what's reasonable or unreasonable, what the amount should have been, what the agreement was in the event that you were fired or not fired.
Your Honor, it always is except for White and Case because they're special and they're different. And their theory below and their theory here is they get to whatever is on their printout, whatever the number is.
but that's not what the Supreme Court judge found. That was their argument.
She says that, no, she says it expressly on, it's on our.
Counsel, as my colleague said earlier, there is no judgment here, and it's set down for a hearing. So
It's not set down for a hearing.
Isn't there a hearing for
No, there's
the
a trial,
amount?
there's going to be a trial in Connecticut on the malpractice case before there's even going to be a hearing here. And of course, one of the issues that should be in the hearing in New York is that since counsel who violate their fiduciary duties or are terminated for cause.
It sounds like you want a ruling from us, setting limitations that will be of benefit to you in the Connecticut malpractice.
No.
That's unrelated to this.
No.
The question here is, what are they entitled to
Right.
pursuant to the agreement? Are they entitled, for example, to a breach of summary judgment on a breach of contract claim?
And the answer is no.
It was a valid contract, right?
No, yeah, and upon 100 years of New York law makes clear that when it is terminated, whether it says pay 100%, pay 150%, or pay 50%, the most they can get, regardless of what the contract says, is the reasonable value of the services completed. That's all this court needs to say. It should say more, but that's all the court needs to say to be consistent with 100 years of precedent.
It's the quantum merit
Yes.
claim still viable?
Well, no,
I know
because there's a
summary
failure of
judgment which is
proof.
granted on the breach of contract.
Yes, but the quantum merit claim they abandoned, they didn't submit any evidence to
Well,
support.
because they got summary judgment on the breach of contract, so why would they bother with a quantum merit?
Well, that's the whole point. And if they cannot actually recover by
You want
enforcing,
us to clarify, let me put it clear. You want us to clarify law that is very clear in the First Department.
to everyone but them in this lower
No, but
court
they can argue
judge.
whatever they want, whether they White and Case or anybody else. We have lawyers always coming to argue here about what they think their clients are entitled to. We have precedent of over, hundreds of years that sets the parameter of that relationship. So the judge sends you to a hearing. In that hearing, a determination will be made of the reasonableness of the fee that they're seeking.
Oh, but Your Honor, also, they want a jury trial. This is the first law firm in the history of how long that wants to smear its client in front of a jury. That's what's really going on here, okay? They don't want to send out to a referee.
Okay.
They refuse.
Well, let me hear from them rather than your characterization of what they want to do. So, go ahead, counsel.
Good afternoon, may it please the court. My name is Josh Berman from White and Case, also on behalf of White and Case.
So why are you not special?
Oh, we'd be here. I really need more than 5 minutes for that. I think that the judgment that Justice Bannon gave was simple, straightforward, limited, and absolutely sound. There was a binding and enforceable contract written down on the paper.
She gave you summary judgment on the breach of contract claim, right?
That's right.
So you have an engagement letter, so you have a valid contract, right?
Yes, Your Honor.
Have they pay you?
Not a penny.
Have you been damaged by the services that you provided or by
Yeah.
the failure to pay the damage? Because
Yes, Your
those are
Honor.
the three elements, right? So now there are all these other extraneous issues that are being raised about you want a jury trial on it. What is that about?
I think at the outset of the litigation, like in every litigation, you have to be careful to write jury trial demanded or you potentially waive it. There's obviously a backlog in the court system due to COVID. So some 18 months has elapsed since Justice Bannon issued her ruling, and we have yet to hear from Chambers on how Justice Bannon would like us to proceed, whether it's a jury trial, whether she proposes that we mediate, whether she appoints a receiver. That's all in the future, and it's for the court.
Sir, do you read anything in Justice Bannon's order as limiting the scope or the damages issues to be tried? You got summary judgment clearly on the issue of liability.
Yes.
And now there's going to be some form of fact-finding and determination as to damages. Did you read anything in Justice Bannon's order to limit the scope of that damages hearing or trial?
Only in as much as Justice Bannon lopped off the quantum merit claim.
Which makes sense since she granted you summary judgment on the breach of contract.
Absolutely. They cannot coexist, and we can concede that freely and openly.
So do you believe at this point, or did you argue before Justice Bannon, that your friend is limited in his proof at the damages stage in any way, shape, or form?
No, he can, Mr. Hayes, the appellant can submit to the finder of fact whatever proof it wants to submit, and we will do everything. This is a painful accusation, to be told that we overbilled and my partners and friends were unethical. We will defend every single time entry on the narrative that underlies the invoice. Right. And the finder of fact will decide who's telling the truth.
And there's still a malpractice, a legal malpractice case going on in Connecticut?
If you can believe it, this is what happened. We sued for fees. There was a counterclaim only for excessive billing, no malpractice counterclaim. Years of discovery go by, both sides change counsel, and at the very end of discovery, we have a status conference before Justice Bannon, and my colleague, Mr. Hayes, says orally to Justice Bannon, I'm going to be filing a motion for leave to amend in order to add a malpractice counterclaim to this case. And Justice Bannon says, this is very nearly a quote, look, you can file whatever you want, you have rights under the CPLR, but I can tell you that at this very late juncture in the proceeding, the court is not going to be hospitable to amending the complaint to add a claim that you had years to add, and that would have the practical effect of reopening discovery and so forth.
I was going to ask why this wasn't a counterclaim.
Yeah, so this is what happened. It was really astonishing. So the Shipmans essentially drive up I-95 to Connecticut. They say the father of the founder of this $500 million company, cosmetics company called The Bomb, has a beautiful home in Greenwich. They say that's actually the company's headquarters, and they file a lawsuit for malpractice in Connecticut. And this was sort of news to me as a New York lawyer, but Connecticut has no equivalent in its what's called the practice book to CPLR 3211A7. And so we've been dragged through a litigation on malpractice that should have been brought years ago in New York if the Shipmans wanted to bring it.
Counsel, there's been no claim in this case that I'm aware of that you were terminated for cause. As I understand the fact pattern here, and correct me, there was a dispute between the partner and one of the plaintiffs where you said, okay, something along the lines of, if we don't get paid by a certain date, pens down or pencil, whatever phrase that is, we're not going to continuing work. And obviously there was some kind of dispute over where you haven't been paid. And essentially that's where we're off. There was no claim that you were fired for cause that I'm aware of on this record.
I think you're exactly right. I can tell this court, if it's interested in hearing what really happened behind the pages of all the briefs.
No, you know, if the source the record, so we won't entertain that, and your time has run out.
Certainly. Thank you very
Thank
much.
you.
Your Honors, I first have to provide the part that my friend completely forgot about. Is that after he said it would be frivolous and sanctionable for us to even move for leave to amend our counterclaims, we then filed a new action in State Supreme Court, 60 Center Street. That's what we did next, immediately and promptly. And then Mr. Berman said that was frivolous and sanctionable, and it should be dismissed. And the case was transferred from the commercial division, where it was properly filed, to Justice Bannon, who then granted their motion to dismiss, but did it on the basis of a prior pending claim, which is therefore without prejudice. So then, and only then, did we go up to Connecticut, where they regularly traveled to meet with Shipman for any meetings around the New York area and file the Connecticut action. I'm sure Mr. Berman will remember that now that I've reminded him of it. And that's why the Connecticut judges, denying White and Case's motion to dismiss or to transfer forum, they made two motions. The Connecticut judges said that for White and Case to complain about Shipman having filed this action in Connecticut was, and they quoted,
Yeah, that's almost a collateral issue to the underlying issues in this case.
So
Bottom line is the summary judgment that was granted to them,
yes, let's do
because
that.
you have a contract, you haven't paid, and you've damaged them in the amount that you
Okay,
haven't paid.
but no, that's not true, Your Honor. It's never been true. It hasn't been true since Martin v. Camp.
So there was no summary judgment granted on the.
Well, there
breach of
was,
contract claim?
no, but that's what's the error is, Your Honor. Under New York law, an attorney, they may be owed $10 million, and if they are terminated, they do not have breach of contract damages for $10 million.
Were they terminated?
They quit, actually. They quit.
They moved
They
to
went
withdraw?
pens down. No, they didn't do that. They didn't give notice. They didn't transition. They just literally said, I am pens down, have a nice weekend. That's in the record. They just quit. They didn't offer to transition. They didn't do anything. They stopped right in the middle of a transaction. And just
But your contract does make provisions specifically for termination and withdrawal.
Yes,
So
but
if they withdrew as counsel, then there were certain provisions. So
Well, they
where's
didn't
the
actually comply.
contract that covered this?
They didn't comply with those provisions, Your Honor. They didn't comply with it says 30 days notice, okay? So they quit and went pens down with no 30 days notice. They did it over a weekend. They didn't comply, Your Honor. And the key thing here, the thing Justice Bannon, her decision takes their pro forma interim draft unreviewed billing records and says, that's our starting point, way up here, okay? And Justice
That's their right to do.
not for determining the reasonable value of the services, no, Your Honor.
So you want them to start by giving half of the documents that they have?
No.
Each side makes their argument. That's why you have a referee to decide the underlying claims before.
Yes, but she switched.
Whether that's reasonable or not is what the bottom line is.
But she switched the burden of proof. She does that expressly. It's in R14, okay? R14 and R15 and R16. R15, she writes, quote, Shipman has yet to make any tailored objection to any fees charged for specific hours of work in the timesheets. Oh, it's the client's burden of proof to say you spent too much time.
That sounds like,
That sounds like a mistake.
Your time has run
That
out.
sounds like reversible error, Your Honor. Thank you.
Thank you. Thank you both. Hernández. Ahora yo sé por qué lo votaron bien.
May it please the court, John Shore for plaintiff appellant. In a nutshell, Your Honors, this is a case where there was an unequivocal violation of the labor law. The record was...
The problem is that you have conflicting accounts of what caused the accident, right? I mean, that's the concern that I have. I mean, Mr. Sanchez seems to have a view, and the record reflects that plaintiff in this case may have been inebriated. So if that was the cause of the accident, would that inform us with respect to whether there was a violation of Labor Law 240?
Two things on that, Your Honor. One, that is gross speculation on his part. He never observed my client fall from the ladder. He never even observed my client doing anything funky on the ladder, which still wouldn't be a basis.
Wasn't the part of an additional problem in this particular case, which is unusual in these construction cases, that the accident was never reported to his supervisor. There was no accident report prepared by anyone, so there is some kind of question as to whether this, I know we don't always require there to be a witness to an accident, but here there's a lot of questions as to whether this accident even happened to be, he didn't even report it.
Two things on that, Your Honor. As Your Honor noted, there's absolutely no requirement that an accident have to be witnessed. And under the Urea case, there's no obligation or burden of a party to even obtain affidavits of so-called witnesses who even witnessed an accident. That is not a bar. Here...
But they brought in, see, that I want to keep going back to this because you said, what you said with respect to whether Mr. Sanchez, the foreman, observed plaintiff before the accident, he testifies directly that he saw plaintiff drinking a Coors Light beer. That's on record at 298. And then he says, he also testified that on July 20th, when plaintiff arrived at 8 o'clock in the morning, he appeared intoxicated, is what he says, since his eyes were red and he smelled of alcohol. And he says that repeatedly, record 282 to 285, 296 to 297, 326 to 327, and 351. So clearly he saw them. I mean, it's not like he said, well, it was reported to me or maybe I... No, he said he saw him. At 8 o'clock, he saw you drinking Coors Light at 10:30. When you came in at 8, you smell of alcohol with red eyes and you smell of alcohol, your client, I mean. So,
right.
So like, how is that not direct evidence? I mean, it may be a great cross-examination that you wind up doing a trial to shed light that one, that's not true. He observed what he did not observe what he claimed he did.
Sure. First of all, right, 8 o'clock, I know the chronology. 8 o'clock, he observed, or he said he smelled some alcohol. 9:30, he saw my client drink a Coors Light. How much he drank, we don't even know. Then he said at 12 o'clock, thereabouts, he saw my client and 3 coworkers at lunchtime supposedly drinking a Coors Light. The accident happened 3 hours later. At no point did he stop anyone from working, and let's go even further.
But there was a reason for that, right? It sounds like plaintiff had been fired, but then reinstated by the brother of the owner, right?
Well,
So the foreman thought, why am I going to fire him if they're going to reinstate him again? They let him work drunk, basically, which in terms, I mean, there's no contributory negligence in 240 claims,
right.
but...
Let's take it one step further. that let's assume my client, even though this is just speculation, that there was a gap of 3 hours based on a Coors Light, that my client was intoxicated while he was on the ladder, which there's no proof.
The fact that you are parsing out all of these little details tells me there's a question of fact. I have never seen a case with a greater clarity about there being a question of fact.
The difference, Your Honor, is...
If a guy shows up to work at 8 o'clock in the morning and already smells drunk and has at least 3 beers by lunchtime, sounds like a question of fact of whether he was still under the influence of those beers and whatever he had the night before.
Even under the Keyjack case, where there was, after when he was taken to the plaintiff was taken to the hospital, there was a notation after this, AOB on the breath. That was not a factor because in that case, it's a similar case, the ladder, and that was a step ladder, he was caused to fall and no one was holding this. In this case, my client was on an extension ladder without even getting into the violations. No one was holding the extension ladder and he and the ladder fell. So hypothetically, even if he had something to drink and it infected him, which there's no proof of, that cannot be the sole proximate cause of the accident because there was a violation of the statute. No one said my client slipped because he was drunk. There's no testimony whatsoever to controvert that. The only thing that is incontrovertible was that he was on this 12-foot extension ladder where no one was holding it, and that ladder moved and fell down. He never said, no one said, I would agree with everyone if there was questions whether, oh, he lost his balance or he slipped. The ladder moved.
Okay,
And even
thank
if
you,
he was
counsel.
on drugs, that he can't be the sole proximate cause.
We heard your argument. Thank you, counsel.
Good afternoon, Your Honors. Joel Simon from the Law Office of Smith Major for the respondent. Respectfully, Your Honor, the sole question before this court was the lower court within its discretion in finding that questions of fact existed?
Well, sir, just summary judgment is a legal question, so there's no discretion. It's a yay or nay, right? So we like to give deference when we can, but here I think we review this de novo.
Understood, Your Honor. And in this matter, Your Honor, the lower court found that there were questions not only as to whether the incident occurred as plaintiff says it occurred, but whether even the injuries were related to the incident that plaintiff claims to have occurred. We have Mr. Sanchez stating that the work that plaintiff states he was doing when he was injured would not have been done by his company, that in fact such work would take 10 people doing it. He states that he has no recollection of being in the room, contrary to what plaintiff himself says. He states that he was not stacking the scaffolding as plaintiff states he was, as the scaffolding would not even fit in the room if it was stacked. He states that he was advised that the injuries occurred from a completely separate and distinct occurrence.
Sir, was the plaintiff the only witness?
Yes, Your Honor.
Okay.
And I completely understand that in and of itself, that doesn't necessarily prevent a 240 finding. But when you have a situation like this, with this many discrepancies, this many questions, it's not whether or not we agree with the lower court's determination, but it's whether deference should be given to the lower court in making this determination. And respectfully, Your Honors, it should be. Thank you very much.
Thank you. Thank you, counsel.
Responding to counsel's statement about whether or not the injury was occurred at this site, that was based on something a week ago that allegedly occurred from some person. It's pure hearsay and not considered or admissible and has nothing to do with this accident at all. It was a week later, and the stuff about whether or not the...
Saying that the broken hand the fracture of his hand that he sustained a week later in a bar fight is not the injury he is claiming he sustained in this fall.
has nothing to do with it because, first of all...
No.
Okay.
I don't need a whole explanation. It's real clear. My question is very clear. So the plaintiff's alleged injury in this case from this fall from the ladder is not the broken hand.
It is the broken hand from this accident.
Then the of whether there was a bar fight where he got that broken hand is at issue, is relevant.
Respectfully,
It is establishing another purported basis for the injury. And if he sustained the injury in a bar fight the week later, it is absolutely relevant.
If, Your Honor, if it was based on personal knowledge, this was, Mr. Sanchez testified that someone named Emmanuel, I forgot his name, told him that allegedly a week later, that is hearsay.
The problem for you is that this is not the only evidence that was put before the court, right? The court didn't base their decision solely on that evidence. There was a lot of things that were the basis of the decision, correct?
That was not even considered.
But what arguably was considered as an issue of fact would be whether he worked outside or inside, whether, who owned the extension ladders.
Whether,
apparently, I'm just saying, but one of the issues is you know, did they supply harnesses? Did he not wear a harness? I mean, there's, as my colleagues have pointed out, the lower court saw the whole record and basically said, you know, it may very well be at the end of the day after trial that you may prevail on a 240 claim, but on this record as it's developed, based upon the conflicting stories, there are real material issues of fact, putting aside whether the injury was a week later or at the time of the accident.
But again, that is based a week later from something that was told allegedly to Mr. Sanchez when this accident happened July 20th, and with respect to whether or not the work was happening inside, outside, Mr. Sanchez admitted, well, I wasn't there for 4 hours during the day. It could have happened. I wasn't there. And in fact, the owner said they were doing work inside as well. So
Thank you,
that is
counsel.
just gross speculation.
Thank you, counsel. Thank you both. Thank you so much. Connor versus Gluck. Oh, man. It's killing me today.
Yoga.
The stress of quitting.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court. Scott Horn, counsel representing the appellant in this matter. Your Honors, the motion court erroneously awarded summary judgment to the defendants because the parties' competing expert opinions engendered a dispositive tribal issue of fact.
Sir, did the plaintiff's expert, in his opinion, rule out uterine atony as the cause of the bleeding? I'm not sure if I'm pronouncing that word correctly. I didn't see that he ruled it out.
No, Your Honor, that's
basically
correct.
he came into his opinion that somehow Dr. Gluck lacerated the cervix, and
Your Honor,
that is the source. And had he or he should have spotted the bleeding and somehow stitched it up in the middle of the procedure in doing the second trimester abortion, correct?
the short answer to your question is yes, Your Honor.
Okay,
But
but in no way did your expert determine that, reject any of the key points that were made by the defendant's expert, that the bleeding was post-operative, that there was no bleeding during the procedure except for the normal type of bleeding, and that she was in recovery where there was no bleeding until it later started in terms of the timeline.
I disagree with that statement, Your Honor. So where I part company with Your Honor is that both experts agree that Dr. Gluck lacerated the cervix in connection with the pregnancy termination procedure. There's no question. Where the parties diverge, so whether it's uterine atrophy, I'm not sure I'm pronouncing that correct either, or whether it's a laceration, that's where the parties part company. So according to the defendant,
But even the
said-
Bellevue records, do you agree or disagree that the Bellevue records determined that the bleeding was as a result of the atony, and that the consumptive coagulopathy was the source of her problem? There was nothing did you see anything in the record, and maybe I didn't see it as carefully as you, did you see anything in the record that the bleeding that your client experienced in that emergent setting was a result of the laceration? There was a finding that that was the proximate cause of the bleeding.
Yes, Your Honor. And I think the most critical document in this record is found at page 109 of the record. And that is the post-procedure report. This is a Park Med record. So to get back to what my...
But wait, what does that page 109 say?
Yes, so the distinction between the two parties is that the defendant says that the laceration didn't occur until after the plaintiff was brought back into the OR, right?
So the bleeding increased at around, what, 11 a.m.? That's what the record 109 says.
Yes, that's before she went in, right?
Okay.
And so the plaintiff is saying that the laceration occurred during the procedure, not after she was brought in. And what page 109 in the record says, in the middle, when she was brought to the OR, and I'm going to quote here, the bleeding was coming from the exocervix, unquote. That's where the laceration was. So how could the laceration have occurred after she was brought back in and certain efforts were made when she was already bleeding from the exocervix?
Because the way I read the defendant's expert's report, the bleeding was caused because of this atony, where the cervix didn't contract appropriately, and that is what caused the bleeding, and that's why they had to bring her back into surgery to fix that up. And in the course of doing that, there may have been some type of, a concern there. The problem I saw was in your relatively brief plaintiff's expert affirmation, he did not even deal with that, with defendant's findings that this was because of this particular situation. So he didn't really address it, and that's the problem I was having.
So I'd like to address those 2 points. First being where the bleeding was coming from. So when you look at the defendant's expert says that under this condition of uterine atony, the bleeding comes from, quote, the lining of the uterus, unquote, at page 430, which is why it's so critical at page 109 in the record that when she was rushed back into the OR, she wasn't bleeding from the lining of the uterus. The doctor says, Dr. Gluck says, quote, the bleeding was coming from the exocervix, the exocervix being the exterior.
But even after the exocervix was repaired and the laceration was sutured, the vaginal bleeding increased and continued and had nothing to do with the laceration that was just prepared, which means that there was additional bleeding. It is not only possible, but expected that after this procedure that you would have continued uterine bleeding for some time after the procedure. So that's not unusual.
Uterine bleeding, yes.
Right.
Absolutely.
And are you saying that it's impossible to have both uterine bleeding and bleeding from a cervical laceration at the same time, and that it would be really hard to determine where the bleeding is coming from at that point.
Certainly not, Your Honor, but if I may just respond
Yeah,
to
go
that,
ahead,
Your
go
Honor,
ahead.
very quickly. The point that I was making in connection with that is that, yes, while still at Park Med, the doctor attempted to stop the bleeding, was unsuccessful, still bleeding, goes to Bellevue. That's when ultimately the suture was correctly done of the cervical laceration. So it wasn't done at Park Med, she continued bleeding, and then they
Is
dealt
there
with other...
something at the second hospital that said we had to correct the suture that was done?
It was done. It said there was a laceration from 5 o'clock to 8 o'clock, speaking metaphorically, across the lip of the cervix, and it had to be sutured. It's in their operative report. So unquestionably, that had to be done at the hospital.
Okay.
Thank you, Your Honors.
Please the court. My name is Peter Taglia. I represent the respondents. What we heard is a lot of things that the expert didn't say, but I'd like to spend a minute or two on whether this was a new theory. And they keep saying it's not a new theory. You only have to look at the bill of particulars. It said that my client punctured the uterus. And there was no claim. That's an act of commission. They switched to an act of omission. You didn't suture the cervix. There was no omission alleged intraoperatively. Secondly, the bill of particulars alleges subsequently failing to appreciate bleeding. That's a post-operative malpractice. Now they're saying it was intraoperative. And you only have to look at the injuries. The injury was puncturing the uterus. Now, off the top of my head, there's 4 ways, and they say, well, everything's the uterus. The cervix is the uterus. So
No, the cervix is not the uterus.
it's part.
And anybody who says that doesn't know anatomy.
But here we had a well-defined injury to the wall of the uterus. It wasn't to the lining of the uterus. It wasn't to the cervix, okay? And then they say, well, the defense anticipated this because his expert covered it. Not true. If you look at my expert's opinions, the last 4 paragraphs, he doesn't mention the suturing. He mentions the bleeding because there was a failure to control bleeding. We didn't get into the suturing. They said, well, you knew from depositions. We did. What in the deposition? They said, well, the plaintiff testified that she was never told about the uterine anatomy, and she told that there was a cervical laceration. From that, I'm going to glean that they said the suture should have been put in earlier. I would have a better chance of guessing what was on the balloons than guessing that theory, and that's why it wasn't addressed. And they keep saying, well, is there prejudice? And I thought about that long and hard. And I've stood before this court before and said it's kind of hard to argue prejudice when the second theory lacks as much merit as the first. But there is a procedural prejudice. Because if they had pled this front and center, I would have addressed it in my motion, and then I would address it again in the reply. But since they put it in with their opposition, I only get to address it once. Since the lower court deemed the new theory had no merit, you really come to the same conclusion. But I want to point out, this isn't like imprecise pleading. This is a totally different theory. So let's look at the merits of the new theory, which is really what the lower court went on. And they cited this court's decision in Dehesus. Look at what their expert said. Not only did he ignore adeny, he ignored that there was DIC. He ignored that there was only 60 centimeters of blood, estimated blood loss, during the termination. That's 2 ounces. He ignored that when the patient was in a recovery room, they only had scant bleeding, and that the bleeding increased. And he ignored, to address counsel's point, that there was a cervix laceration. No, they said the bleeding was coming from the uterus. When he took the patient back to the OR, and he was taking him back to look for retained products, because retained products is one of the causes of uterine anatomy, he noted the cervix was intact. It had not yet been lacerated. So their expert ignores all these facts.
So do those omissions render the affidavit without any probative force, or would they simply go to wait if you went to trial?
An expert affidavit has to be based on a fact. An expert, and I made this argument before, if I go to a doctor and I have pain in my right arm, and I walk out and have a heart attack, my wife has a pretty weak case. But if I find an expert said, no, the pain was in the attorney's left arm, an expert can't change the facts. He's got to deal with the facts in the record. He can't ignore them. And this expert just assumes there was an injury to the cervix. And one other thing I want to point out. They say they debunked the uterine atony theory. And they do it on two bases. And I don't know. They said that nowhere at Bellevue Hospital did anyone diagnose uterine atony. And then in their reply brief, they say, it's not mentioned whatsoever. And I said, well, did I cite the wrong pages? And it's right there on page 151, the ER record. 152 and 178, the doctor, Teresa Walker, who did the operation, she said there was uterine atony. So the expert ignores the uterine atony, ignores the DIC, yet they say they debunked our theory. And they also say they debunked our uterine atony theory because there were no retained products. I thought the way you debunk a theory is to have your expert debunk it, not to have an attorney in a brief.
Did the expert address it at all, the uterine?
He doesn't mention it.
He doesn't mention it.
And I should add this, and I hate to be technical, it was in our undisputed statement of facts that she had uterine atony. So there was two reasons why they should have addressed it. They should have said the statement of facts is wrong, and the expert should have said, I disagree. This wasn't uterine atony. And not only uterine atony, she had DIC. He ignored both of them. So, he had one paragraph on the departure, one paragraph on, and then he just says, well, had this not happened, she wouldn't have had to go to Bellevue. Well, how do you treat DIC? In the office? You treat uterine atony? He never explains. How would she avoided going to Bellevue? And she was only there 24 hours, and in that 24 hours, they mentioned uterine atony 3 times. And when a record is word searchable, I don't know how you could say in your brief twice that it's not mentioned anywhere in the records. Thank you.
Thank you, Counsel.
Very briefly, Your Honors, on the issue of whether or not it's a new theory, I think the important distinction here is that the theory of malpractice is not the laceration itself. That's not what the plaintiff's expert is saying is the departure. The departure is failing to timely identify it and rectify it. And when you look back into the bill of particulars, there are specific allegations that say failing to appreciate the signs, symptoms, complaints of the severe pain and blood loss, failure to find out the source of the blood loss.
Counsel, you don't think that your your expert had an obligation to at least address this claim that the bleeding was caused by the condition of uterine atony? I mean, that is a major portion of what the defendant's expert talks about. Doesn't your expert have an obligation to address that? Because otherwise it sounds like I'm reading experts' affidavits from 2 different cases.
I would have slept much better last night had he addressed it, yes, Your Honor. However, I think under the circumstances, however, again, looking at what the actual theory of malpractice is, it's not the cause of the bleeding. So the cause of the bleeding is secondary
but the problem is when you have the opposite side's doctor saying the cause of this is X, Y, and Z, the opposing expert has to say X, Y, and Z is not the cause. The cause is A, B, and C. You've got to address the cause that's being asserted by your opposing side. And he doesn't do that.
I understand, Your Honor.
We looked, trust me,
yes.
several times.
No, I understand that, Your Honor. And the last point I would like to make with regard to the statements regarding what was and was not in the record, if you look at the respondent's brief at page 8, footnote 3 is where they make, and if I could just finish this point, it'll take me about 20 seconds.
Page 8?
Page 8, footnote 3. So that's where the respondents made the argument that the diagnosis of uterine atony is clearly set forth in the hospital records. And then if you look down in the footnote, there's 2 pages cited. Neither one of those pages are pages that counsel just referred to. That's where the basis for my argument in reply is, well, those pages don't say uterine atony in those Bellevue records. Thank you, Your Honor.
Thank you. Thank you both. Bonacardi?
I'm recused.
Okay. Justice Manzanet Daniels is recused
Okay.
in this case.
Okay, good afternoon, Stephen Bergstein for the petitioner appellant. The petitioner Bonacardi was entitled to an evidentiary hearing on whether she was terminated from her position in good faith.
Sir, you don't disagree that the law is clear that a probationary employee can be fired for some reason or no reason at all, correct?
I'm not sure that's true. The cases say you can't be fired in bad faith.
Right.
So
But that bad faith usually refers to a discriminatory reason.
No, it doesn't.
Or some other basis.
No, it doesn't.
That's-
The cases in our brief show, as long as the dismissal is not unlawful or in bad faith. The Court of Appeals has said it, this court has said it, the Court of Appeals in Duncan v. Kelly, Verma.
Smith, which is this appointment's case as late as 2022, Monroe Smith versus New York City Department of Correction, stands for the proposition that in the absence of a showing that her dismissal was in bad faith or for a constitutionally impermissible purpose or a violation of law.
But bad faith or
Right.
constitutional.
Okay.
So bad faith is bad faith if it's a nonsensical reason. And there are cases where the petitioners have won, not because it was illegal or unconstitutional, but because it was in bad faith.
Okay, so the bad faith, the burden is on you, right? So what is the bad faith?
Bad faith is that they have advanced, by my count, 13 allegations that she was a bad worker, had a bad attitude. Her affidavit in further support of the Article 78 refutes each and every allegation they made against her with emails, text messages, her sworn personal account of what really happened during all of these episodes, and all they have is a memo from somebody who wasn't even there when some of these episodes purportedly took place. So you have hearsay, and then you have, on the other side, our client's detailed affidavit with as much evidence as she could muster, showing either something didn't happen at all, it just didn't happen, or here's what really happened. And you know, I wasn't AWOL, for example. I sent a text message that morning saying I was sick. I didn't leave the office in the middle of the day and not come back and nobody knows where I was. I sent an email saying I'm not feeling well, I'll be back later. That's why this is bad faith. And
Sir, if we agreed with you, would we be essentially treating the petitioner as a tenured employee then? And giving her the rights of a tenured employee?
no, but the cases say that even probationary employees can win if they can show that they were fired in bad faith. Look at this court's ruling in Castro versus Sherriro, First Department 2016. Castro was fired because an inmate died, and he claimed that they were blaming him for things he didn't do. There was no claim that Castro broke. There was no claim that he was fired contrary to law, that it was unconstitutional.
So basically you're saying that the point is that, or the question is whether her affidavits as to what actually happened with respect to her performance, for example, warrant an evidentiary hearing.
Exactly.
At least with respect to
Exactly. Whether her affidavit plus the exhibits create an issue of fact. We're not saying we win as a matter of law, but I do want to emphasize that the cases say that bad faith doesn't necessarily mean that it's illegal. The word "or" usually follows bad faith in the way this court analyzes these questions. And, you know, the Supreme Court simply took the city at its word and said, well, we're not fact finders here. We're just deciding whether, you know, they claim she was a poor employee. That's not the analysis, unless she can't dispute what they're claiming. But she does dispute what they're claiming. And, you know, 13 allegations and she disputes all of them?
But you agree that even after a hearing, it's not whether they had any good reason to fire her. That's not bad faith.
Bad faith is they're raising issues which cannot be true, you know, where you know, we claim that you were AWOL and we didn't know where you were, and she comes back and says, wait a minute, I have an email from 8:35 in the morning, so I wasn't AWOL. That's bad faith. Thank you.
Thank you.
Good afternoon, Rebecca Viscatas for the respondents. Supreme Court properly denied Bonacardi's petitions. As Your Honors have recognized, she never even alleged that she was fired for a particular bad faith reason. Instead, she makes the conclusory argument that because she believes she did nothing wrong and she disputes many of the issues that her supervisors had, that her dismissal must have been in bad faith.
Well, let's say for a second that she controverted each and every one of the bases for her termination. If she was right on each and every one of those bases, that she had not violated work rules, violated work procedures, wouldn't that be demonstrative of bad faith, that there was essentially no reason for her termination?
No, I think that even that would require a drastic expansion of what constitutes a bad faith dismissal, and one that would really swallow the rule and essentially convert probationary employment into tenured employment, as Your Honors recognize, or something that would require just cause for dismissal. But also, crucially here—
So even if there isn't a good reason, that doesn't necessarily constitute bad faith.
Exactly. And also, here, she did not dispute each and every one of the allegations. While she offered excuses or offered her reasoning for some of them, there were performance issues that she acknowledged happened, that she complained about being asked to answer phones one afternoon, leading her supervisor to express disappointment in her reaction. She didn't email her direct supervisor on one day when she was out sick. She emailed someone else, but she had been instructed to email her direct supervisor. She didn't follow up about a missing orientation link until it was too late to join. And while she offers her reasoning behind some of these things, her supervisors didn't have an obligation to inquire into her reasoning before making the decision to terminate her a few months into her probationary period. This is exactly what probationary periods are for, to determine whether someone is a good fit for the office and their expectations for that position. And here, she simply has not demonstrated any indication of bad faith.
What is your understanding of the concept or the contours of the bad faith component of this doctrine that permits a probationary employee to seek some sort of redress via Article 78?
Sure. I think that the contours are not entirely clear, and the case law historically seemed to treat it as synonymous, bad faith as synonymous with unconstitutional or statutorily impermissible. The wording has shifted a bit to say bad faith or those reasons. I don't believe that it necessarily needs to encompass anything more than that. And in the Castro decision that petitioner points to, even there, the petitioner had offered a potential bad faith reason, essentially suggesting that he was being treated as a scapegoat, as sort of the lowest ranking person involved in an inmate's death. And perhaps that situation, based on this court's decision, might be a unique circumstance that would go beyond specific violation of the Constitution or a statute. But in general, I think bad faith is meant to encompass those things and nothing more, Your Honor.
Okay, thank you.
Thank you.
Bad faith can't encompass both things because the courts say it's bad faith or something that's unconstitutional or contrary to statute. And again, we're not looking for a drastic expansion here. We're applying Castro. Look at the cases this court cited in Castro in support of ruling in Castro's favor. Higgins versus LaPaglia, Third Department. The plaintiff was fired. He raised a substantial issue of bad faith because he wasn't properly trained for something they claimed he did wrong. That was it. That's enough to show bad faith. The Ramos case from 1970, still good law because it was cited in 2016, whether he was in reality fired as a result of a personality conflict with a supervisor. That's bad faith. Bad faith is sort of like pretext. Like in a discrimination case, they raise an issue that can't possibly be true because the plaintiff is able to show that they're just making it up, or that it's not as if there's a judgment call and I disagree. I was actually a great worker, and you say that in a conclusory way. That doesn't fly.
But even Castro talked about bad faith just being some sort of improper basis for termination, or something that they claim. can
No.
be imputed to her, to the employee, but not be it. And I mean, Castro says that at 648, 148D3 at 648, right? Petitioner's failure to perform his or her duties satisfactorily may not have been due to some improper basis, is what Castro says.
But it also talks about bad faith or an improper or impermissible reason. That's on page 649. But
No, and basically that's why Matterall Smith, which is as late as 2022, says bad faith for all constitutionally impermissible purpose or a violation in law. So you're right in that reading.
so
It's a beach ball. You get to agree with me on that one.
I just cite the language in our cases that make it clear that, you know, a pretextual reason, I guess is the way we're
Right.
phrasing it, is,
Okay.
you know,
And that's what happened in Castro. They say it was one thing, but he actually.
it's one of the
turns out it was
benefits,
another.
one of the benefits of working for the government is that there's some protection against a completely pretextual false reason that has no basis in fact. And I know that, you know, in many cases, the plaintiff loses because they simply disagree with a bad performance review. But when you have 13 allegations and she raises questions about all of them, the question is what's going on here. All we're asking for is an evidentiary hearing.
Gotcha.
Thank you.
Thank you. Thank you both. Last is Hebard versus American Finance. Okay, so what do we got here? Oh, you guys wanted a lot of time, huh? Let's start with this.
Good afternoon, Your Honor. May it please the court. This is, I am Lee Squitieri for the plaintiff appellants. And we are here arguing for reversal of the denial of leave to amend. We think that denial of leave to amend based on the Maryland statute was a clear abuse of discretion.
Well, we have a history here where the Southern District action, as affirmed by the Second Circuit in their summary order, seemed to make it clear, and I'm going to be generic about it, that all the proxy material that discussed that third agreement that's at issue here that led to the merger was fully disclosed to the shareholders, and they had a full and fair opportunity or notice, which is the right word, and they voted and ratified it. You don't dispute that, do you?
I do not dispute that, and that is why we withdrew the proxy claims and we withdrew the non-disclosure claims. And in fact, the action took a new form in the proposed amended complaint in the form of a shareholder derivative action. What was brought in the Southern District were claims based upon proxies. Okay, those could not have been brought in the name of the corporation because the corporation doesn't vote on its own proposals. Only the shareholders vote. So that was a shareholder direct action for money damages based on a proxy. The proposed amended complaint was a shareholder derivative complaint brought in the name of and for the benefit of the company.
So why does that make a difference in light of the Maryland statute?
Why does that make a difference in light of the Maryland
why do you
statute?
think? I mean, the court basically found that disagrees with you, right? I mean, was there a provident exercise of discretion, or was it error to examine the merits of your amended complaint in light of, and I'm looking for the section, section 2-419.
2-419. 2-419, it was error to do that, to take that statute, apply it to the proposed amended complaint, and deny amendment of all the claims. Why? Because the statute has limitations and requirements. It is what is known as a safe harbor statute. That means If its requirements are satisfied, there can be no claim. It's not part of a prima facie claim. It is a safe harbor, as they say. It requires a shareholder vote on the subsection we're talking about here. And if applicable, it precludes voiding or making voidable the transaction. That is why it was an abuse of discretion to apply.
So why, I mean, it's the reading of a statute, right? So the court can read it and determine its viability, right? So the question is whether Section 2-419 applies, right?
Correct. Correct, Your Honor.
And you can do that by just looking at the merits of the complaint.
You can do that by looking at...
Look at what you are alleging, right?
Very...
Look at the transactions involved here. You can do that through looking at the Southern District decision, right?
Well, no.
I mean, some of
It's a
that
different
stuff-
claim.
Okay, so let's assume that. You look at the interested director.
Right.
And whether the agreement was approved by a majority of the disinterested directors, which is what the court did, right?
Yes, Your Honor. But while the court actually just focused on the shareholder vote subsection of the statute, and the court said...
Well, it's disinterested directors or shareholders, right?
Well, that's another subsection, but the court didn't get to that. There's actually 3 subsections. One is disinterested director vote, 2 is fully informed shareholder vote, and number 3 is the transaction fair and reasonable to the company, which they never invoked, by the way. No defendant has ever got up and said to the court, 2-419 applies because of subsection 3, it's fair and reasonable. So it has 3 separate and distinct things. The court only got to the shareholder vote. And the abuse of discretion, the clearest abuse of discretion, is to take a statute that says, if there is a fully informed shareholder vote, the transaction cannot be voided, and to apply it to claims for damages based on fiduciary breach, waste, unjust enrichment, and aiding and abetting.
But the shareholders agreed to it. I mean, there's no dispute. Look, there's no dispute that the proxy materials telegraph, so to speak, that this agreement is very different than any other prior agreement in terms of the 20 years, in terms of the internalization fee, in terms of all that negative stuff that your client claim affected their value of their shares. Fair, but they knew about that. It was right up front. So you're saying breach of fiduciary duty, corporate waste for paying all these commissions, and then preventing us from really wanting to manage our own REITs because we have to pay
$125 million.
But they voted for it.
Your Honor, we dispute that they voted for the 3rd advisory agreement.
But where is the provision in the statute or anywhere else that says that they had to separately vote on the 3rd advisory agreement? They were voting on the merger. They knew from the documents that were submitted in preparation for the vote on the merger that if there was going to be a merger, part of what was going to happen was the adoption of the 3rd advisory agreement. So I couldn't find someplace, unless you can show me where, that said there should have been a separate vote on the advisory agreement. I thought it came with the merger.
That is the area of controversy, Your Honor. The statute is silent, and believe it or not defendants, not me, not the court, could find a Maryland decision on point. But what we did find were the Delaware cases I cited. And the Delaware cases say there must be a separate vote. And the Maryland case...
How is that relevant to our case here?
It's relevant because there was no separate vote on the 3rd advisory.
I get it. I understand that. But what I asked you is where was that required. Everybody was told, I mean, I might not have voted for this arrangement, but I'm not a shareholder. Maybe you wouldn't have, you weren't a shareholder, but enough of the people that were part of the companies did vote for it. And there's no place I could see other than these Delaware statutes you're telling me about that I don't think are
I'll
applicable.
give you 30 seconds to respond to that.
Your Honor, as I just said, the statute is silent on what the vote has to be on. The third advisory agreement was not part of the merger agreement. The shareholder proposal on ballot said vote on
I
the
thought it
merger.
had been included as an
But it was
exhibit.
included in the documents. They knew that this was part of the deal. They knew that if they voted for the merger included the third advisory agreement, and the documents that went out said, by the way, this is going to have the 20-year arrangement. So I don't see
Your
where.
Honor, that's true, but the vice of tying one to the other is that, did they vote on the third advisory agreement, or did they just want the merger?
Everybody who voted had to read all of the material that was provided, period.
But there was no way to get the merger without.
Okay, you got, your time ran out on, I'll give you a few minutes in rebuttal, so counsel.
Okay, thank you.
I'll let you go for a minute, but I mean, I wanted to know what was included in that merger document. Because that seems to be like, they claim, we knew nothing about it, we didn't take a vote, we don't know what they took a vote on, so.
Your Honor, so first, Audra Soloway from Paul Weiss. I'm here on behalf of all of the defendants' appellees. And, let's start right away with that issue. The proxy that went out for the shareholders to vote on this merger had pages and pages that detailed between the independent directors of one REIT and the independent directors of the other REIT, a many-month-long process where the special committees negotiated the terms of this third advisory agreement. The agreement is described in detail in the proxy. It is attached. There is zero question that the shareholders were given all of the information. And on this very august occasion, and being the last argument today, I'll also mention you are the third appellate court to hear arguments about this merger and about this third advisory agreement. Both the Fourth Circuit Court of Appeals and the Second Circuit Court of Appeals have addressed various issues relating to this agreement and have held that every term was adequately disclosed, including arguments about the third advisory agreement, including arguments about the internalization fee that's challenged in this case. There is zero question that all of the shareholders knew what they were voting for, and they in fact voted on it.
Well, I'm not sure about that, but I mean, I think that I'm saying I'm not sure everybody read it, is what I'm saying. But what I think I'm not trying to fight with you about is that you may have put it out there in the documents, and it seems that you even said, look at this, these are big changes from the way it was, take a look at this, maybe you're interested in
Absolutely,
reading this.
and this is not a small agreement, Your Honor. A REIT that is externally managed has an independent board of directors, but all of its other operations in this case are managed by an outside advisor.
And
this is the core agreement.
Am I correct that in a REIT such as this, those who can invest, the shareholders that are permitted to invest, have to be at a certain level of sophistication and net worth? So these are not your average Joes, right, who can invest in these REITs. Am I correct about that?
My understanding, Your Honor, is that there are some eligibility criteria, yes.
Yes. And this was two REITs that were joining forces so that you would have external teams of lawyers on both sides negotiating this for months and months and
More
months.
than lawyers, Your Honor, more than lawyers. We had outside advisors hired by both sides' board of directors, separate counsel, and different independent directors on both sides negotiating this. I want to turn to the statutory argument because I think there's also just no support in the statute for the argument that's being made here. Not only was this clearly presented to the shareholders for a vote, but the statute that the plaintiffs are now interpreting, and by the way, I should say, none of the arguments that are being presented on appeal were presented to the trial court. So most of the arguments that you are hearing, if not all of them, you're hearing for the first time.
Let's assume that they,
Fair enough, Your Honor.
pure legal arguments based on the section 2-419, so.
Fair enough. The language in the statute says contract or transaction. Now, the plaintiffs myopically focus on the word contract and say that must mean one contract and one contract alone. That's not what the statute says. But most importantly, the next word is or transaction. There is no M&A transaction that can be conducted with one agreement. Every M&A transaction is one with multiple agreements. This is the most important of all the agreements that form the basis for this merger. So the notion that you can single out this one agreement, which was, as multiple courts have now held, conspicuously described and adequately disclosed, it's not supported by the statutory text. So let's turn to the case law. It is correct that the plaintiff in this case has identified some Delaware cases that the plaintiff contends do not support the proposition that you have to put these things to the vote one by one. The problem with the cases that the plaintiff has cited is that the facts are totally different. In one case, the challenged course of conduct happened after the vote. In another case, it had already been implemented before the vote. There is no question, again, based on the papers in this case, that the contract at issue here, the third advisory agreement, it didn't spring into effect unless and until the merger vote went forward. And there happens to be law on this that we cite in our papers that says that in that situation where you're talking about agreement, I want to make sure I get the words exactly right, that is, quote, necessarily attendant to the merger and self-executing upon the merger closing and fully disclosed to and approved by the voting shareholders, that this provision does apply, and that's the case, Your Honors, that we cite, the Solomon case, which is a Delaware case. So no Maryland court has, to my knowledge, interpreted the statute, but even if we want to look to Delaware to see what guidance Delaware has.
Maryland always looks to Delaware for guidance, right?
Actually, it's interesting, Your Honor. They often do, but on certain issues relevant to this case, Maryland has an even higher standard, including, for example, pleading demand futility.
Okay.
Just a separate issue on the statute. The statute, as we know, expressly talks about protecting a qualified transaction from being void or voidable. What is the strongest authority you have that holds or indicates that the protections of the statute insulate from tort liability?
So thank you for asking that, Your Honor. There are multiple cases cited in our brief that address precisely this point. First of all, it has been held to apply to derivative claims, which is the Shapiro versus Greenfield case. So the notion that this statute doesn't apply when directors and officers are having their fiduciary duties challenged, Shapiro addresses that. Then there's also case law that says that it applies to damages claims. So the idea that this is only about voiding a transaction, it's not. And probably the best case for that, Your Honor, is the Miami Pension Plan versus Starwood case. And what is the reason for that? And the Starwood case explains that. The concept here under Maryland law is that informed shareholders, quote, can easily protect themselves at the ballot box by simply voting
no, right?
No, correct. And judicial second-guessing has little utility. And so the whole reason for this statute, Your Honors, is that if you disclose something to your shareholders in the context of a related party transaction, which this was, and your shareholders vote on it, it shouldn't be second-guessed later. We have a number of other grounds, by the way, that we have identified in our papers, but I'll leave it on the papers for that.
Thank you so much. Okay, I'll give you a couple of minutes, counsel, because you took a lot in your front argument.
I did, Your Honor, and I thank you for that, and I'll be brief. I won't belabor the point about the separate shareholder vote requirement, because I think I'm swimming upstream on that one. And as far as disclosures go, this is not a disclosure case. So let's zero in on 2-419. It is limited in its scope. If every requirement is satisfied, all it means is that the transaction is not void or voidable. That means my wherefore clause, Section C, to rescind the transaction cannot be brought. It does not apply to tort liability. It is the case they cited is one case in their brief, and that case said if 2-419 is applicable, there is no liability to the shareholders. That case was just one case in Maryland, and it was limited to its applicability for liability to the shareholders, not to the corporation. This court, the trial court, went far beyond the application or any reasonable interpretation of the application of 2-419 to deny amendment of every single claim. If you have any other questions, Your Honor, I'm here.
I think we're good. Thank you so much. Thank you both.
Thank you.
Thank you so much.